Welcome, Representative Cornish. And is there someone that would like to move House File 222? Representative Johnson would like to move House File 222 and have it re-referred to the Committee on Public Safety. Representative Cornish, go ahead. I believe you have an amendment.
Madam Chair and members, we don't have an amendment, but I think you do.
Representative, Representative Cornish, I think you had the DE1 from last time. Are you not offering that? It was submitted again. Were you not going to offer the DE1?
Yeah, I believe it was not the one that we didn't act on last time, we didn't vote on last time. No vote. It was just-
That was my amendment from last time, and then it was held over without action, right?
Right, and so
Okay,
would you
I
like to take it
understand
up?
now. Yes, please.
Okay. Representative Johnson moves the DE1 amendment to House File 222. If you want to go ahead and explain your amendment, that would be fine.
Yeah, we want to do that last time.
Madam Chair, unless you want us to, I think we walked through that last time, and I would just continue on with the bill.
Okay?
And would you entertain putting up your amendment, then I can react to the whole bill with the amendment,
Okay.
to save us a lot of time.
All right, all those in favor of adopting the DE1, please signify by saying aye. Aye. Those opposed, same sign. The DE1 is adopted. And then, members, I have the DE3, and I would like to do a walkthrough with you on the DE3 that is amended to the DE1. And although Representative Cornish's amendment was an improvement to House File 222, I feel that we need some tighter constrictions on this data, and so that's what the DE3 attempts to do. Representative Lesh.
Could you briefly state, I have been remiss and I am not tracking the changes that Representative Cornish made in the DE1. Could
Okay.
you just briefly state what they were?
Representative Cornish.
I'll turn that over to my testifier, Madam Chair, if you don't mind.
Okay. Please state your name for the record.
Madam Chair, members, the language that was proposed really began to...
Please state your name for the record.
I'm sorry.
Thank you.
Paul Schnell, the Chief of Police for the City of
Thank you.
Maplewood, and a member of the Minnesota Chiefs of Police Association. It began to it laid out essentially, identified what the systems were capable of, identified the conditions under which and how the data would be classified as non-public. It had the provisions of a 90-day point of retention through which that data could be accessed by the law enforcement agency when there was an active and open investigation. And it had a number of conditions through which law enforcement agencies were required to maintain access logs. Personnel were required to secure authorization in writing prior to accessing the data. It had a reasonable suspicion requirement for accessing the data. And it also had the requirement that we would notify, there would be notification, public notification of the use of the technology and the placement of fixed or stationary units that were put into service throughout Minnesota.
So,
Those were the essential components.
Representative Lesh.
Madam Chair, thank you, Chief. And so I'm curious specifically about the reasonable suspicion standard that you put in. What kind of hoops do you have to jump through as a chief then to get to that? And how is the written justification saved?
Chief Schnell.
Madam Chair, Representative Lesh, the requirement of reasonable suspicion would be that we would have to have an articulable set of facts that would suggest that the data that we may possess would be pertinent to an active and open investigation, including a case number, and we would need to lay a basis for that. An employee, as a for instance, an employee or investigator with Maplewood would be required to present that to me or another command staff if they were so designated. Ultimately, I would be responsible as the chief law enforcement officer. They would make the case essentially that the conditions are met, what the case is, and they would identify a kind of a brief factual basis for what it is they are, why it is they need to access this, and how it's pertinent. And we would establish those sets of facts to determine reasonable suspicion.
Okay, Madam Chair.
Representative Lesh.
And Chief, what would the consequences be for a law enforcement official that failed to do that, or maybe got squishy about the facts? Because this is not going before a judge at all, of course, right? So what would happen to that data or that investigation if the procedure were not followed?
Chief Schnell, was that outlined in either the amendment or the bill?
Madam Chair, it was not specifically discussed, although there was provision set in the legislature last year. There was audit requirements that would need to be accomplished with this bill. That I would identify that, number one. Number two is that the accountability measures that were identified by the legislature last year, were there to be wrongdoing on the part of an officer, would be something that they would be subject to.
Well,
Representative Lesh.
Madam Chair, the reason I'm asking is, under the traditional system that we use, if there are either unlawful or unconstitutional actions taken in order to procure certain evidence, the exclusionary rule applies, which means, it can't be used in court. And everyone has dealt with that for 60 years. And so I'm assuming, and the reason for that is, normally it goes before a judge, right? A judge signs off on the warrant, or she doesn't sign off on the warrant. And then if the parameters of the warrant are breached, well, then the exclusionary rule applies. Well, in this instance, there's no judge signing off on it. And I presume it would fall under another standard, what we call in Minnesota as a Rasmussen hearing, to determine whether the evidence has been legally obtained. I'm trying to wrap my head around how it works in this way, if it would just work in the same way, despite the fact that there was no judicial intervention.
Chief Schnell.
Madam Chair, Representative Lesh, I think I understand the issue that you're identifying. I would say, however, that law enforcement officers around this state and around this country are making decisions on the basis of reasonable suspicion every day. And while certainly there have been times when those judgments have been in error or wrong, and to your point, there is or would be mechanisms whereby they could be held accountable and or that data could be excluded in a case through a Rasmussen proceeding, as you suggested or identified. But ultimately, I believe that the provisions that are laid out do provide clarity for why we're accessing the data that would be publicly available, that people would be able to see what was the reason, what were the set of facts that ultimately resulted in the need to secure authorization to access the data that we may have on non-hit data for purposes of attempting to further an investigation.
Great. Well, thank you, Madam Chair. Just
Representative
briefly, and thank you for that, Chief. This amendment then represents, I think, a forward step on the part of law enforcement. I still have some concerns, but thanks, I guess, is what I'm trying to say for offering this. That's all I'll say for now. I'll wait to hear about the rest of the bill, Madam Chair.
Thank you. Representative Johnson.
Madam Chair, Chief, when you first got your LPRs, I take it you had a personnel policy put in effect on how they're properly used. Is that correct?
Chief Schnell.
I assume
Madam Chair, Representative Jensen, yes, we have a policy that dictates how these systems are to be utilized and accessed.
Representative Johnson.
I know I've talked to a number of chiefs, a number of sheriffs that have this equipment, and all of them have policies and procedures put into place And what they've informed me is if there, in response to Representative Lesch's question about people misusing it, when it's in a policy, discipline can be immediate. So it actually works much better than statute, which can take a long time because the assumption of innocence until proven guilty in court. So disciplinary actions could be taken immediately and issue resolved for improper use of the technology.
Thank you, Representative Johnson. Representative Holstrom.
Thank you, Madam Chair. Chief, could you tell me if they use the search of the non-hit data, that'll be documented in a supplement by the officer, is that correct?
Chief Schnell.
Madam Chair, Representative, yes, that would be fully documented, that what they accessed and whether or not it proved fruitful in furthering the investigation.
Madam Chair?
Representative Holstrom.
Thank you, Madam Chair. And Chief, the defense attorney would get a copy of all of the discovery on whether or not they, how and for what purpose they access that data, is that correct?
Chief Schnell.
Madam Chair, Representative Hilstrom, yes, they would be provided with full access to all data pertinent to the investigation.
Representative Holstrom.
Thank you, Madam Chair. And so at some point, if the defense attorney wanted to bring a motion before the court to have that information excluded, they would have the ability to put the officer on the stand to testify about how and why he used that data. Is that correct?
Chief Schnell.
Madam Chair, Representative, yes, that happens routinely.
Representative Holstrom.
Thank you, Madam Chair. And the judge would have the ability to exclude any of the data that was collected if they felt that it did not comply with office policy or state statute. Is that correct?
Chief Schnell.
Madam Chair, Representative Hilstrom, yes, that is correct.
Representative Holstrom.
Nothing else. Thank you.
Thank you. Any other questions on the Cornish Amendment? Seeing none, I'll begin a walkthrough of the DE3. First of all, on page 1, section 1, it just states that there is an inventory that is required and that inventory will be public. It also covers the definition of surveillance technology. The report requires reporting to be done once a year on the inventory that is maintained and used or may be maintained and used if they're prospectively thinking of purchasing an ALPR or some form of technology. If you go to page 2, there's definition of what an ALPR is and the limitations to the data collected by the ALPR, and those are listed on lines 2.28 through 2.30, and those limitations are the license plate numbers, the date, time, and location data on vehicles, and pictures of license plates, vehicles, and areas surrounding the vehicles. Collection of any data not authorized by this paragraph is prohibited, so it is limited to those specific things. It is also, the data would be classified as private unless, but it could be classified as well as active criminal investigative data. And so that also would be non-public data until after the investigation is completed. Top of page 3. There must be additional evidence and reasonable suspicion to classify it as active criminal investigative data. Moving on, under letter C, the agency cannot develop or organize its own data files, nor can it make a centralized repository or develop a centralized depository for all this data. It cannot be used to target or track persons at specific locations without a warrant. And then what this amendment does is it allows for 7 days retention by law enforcement. If you look at line 3.22, some of you know that there's a program called the Safe at Home program, and this is an exemption for that, so that those victims of domestic abuse would not have any of their data made public. Moving on to subdivision 4. In order to share data with another law enforcement agency, a subpoena must be obtained. In the case of the feds wanting any of this information, the data would have to be related to the commission of a crime. Moving on, data from an LPR cannot be shared with, disseminated, sold, or traded with any other individual or entity unless specifically authorized by law. Subdivision 5 talks about the log, that there's a log of use required. It specifies what must be kept in that log of use. And as you can see on page, or on 410, that the list is not limited to just these things, but it can be, it expands to similar categories of information. Let's see, should be a quarterly audit, and that would include, and that would be an independent quarterly audit done by an outside entity. It would audit the records to determine whether the data currently in the records are classified correctly, how the data are used, and whether they were destroyed as according to this section of law. The results of the audit are public, and the audit shows that a law enforcement agency, if the audit shows that a law enforcement agency is out of compliance with the requirements of this subdivision for more than 2 times in a calendar year, 2 consecutive audits, then that law enforcement agency would have to suspend its operation until the legislature authorizes them to continue using it. A report summarizing the results of each audit must be provided to the chair and the ranking minority members of this committee or the committees with jurisdiction over this section of law. For authorization of data, the responsible authority for a law enforcement agency must establish written policies to ensure that law enforcement personnel have access to the data only if authorized in writing on a case-by-case basis by the chief of police, the sheriff, or the head of law enforcement agency. And it tells under those parameters what information must be present in order to access the data. The next section is very similar to the law that we put in place surrounding MNsure, as far as what happens with, no, actually, this isn't that section. This talks about unauthorized access and by an employee. And if the employee is found to be negligent, they could get up to 6 months, or they would get a suspension without pay of 6 months. If they're found to willfully abuse this part of law, then they would be subject to termination. Let's see. The next section talks about the notification to the Bureau of, to the BCA, and that any agency that acquires an LPR technology would have to notify the BCA of what that is, what they've purchased, and within 10 days of installation. Subdivision 10 talks about First Amendment activities and states that an automatic license plate reader may not be used at any event, activity, or assembly subject to the protection of the First Amendment of the United States Constitution without written authorization by chief of police, sheriff, or head of law enforcement agency. And then finally, in section 4, the agencies would have to have a policy, which as far as I know, the ones that do have a policy, or do have LPRs, do have a policy, but it would have to encompass the laws in this section of law. So with that, I know Representative Cornish would like to first make some comments on the amendment, so I'll let him go.
Well, Madam Chair and members, I'm still looking for a way to reconcile this bill. I and law enforcement are totally against the amendment, and we had wished that it be voted down, and I'll go into the reasons why. But I do thank you for the move on retention, but everything else seems like it got buckled down where the bill it'd be completely useless. In fact, if it came to my committee, which it is, I would probably hold it over. The law enforcement's credit, they want to continue working on the solution. I told them to pull this pin on this bill several days ago, because with it, it basically neuters and eviscerates the whole bill with this amendment. I mean, it's worthless. So if it comes into my committee, I would have to change it completely around to suit us, and therefore, there'd be a big fight in the floor. And as we all know, leadership isn't going to let this bill come to the floor if we're not in agreement. So if the amendment is added, I see this as probably an end to the reconciliation of this whole bill. And if I could love to finish the presentation here, it's just that we thought that we were really serious about coming to a resolution and wanted a negotiated agreement. But when you talk about quarterly audits, I'd have to ask research if that's even done anywhere, and how you define the amendment, whether they could set up outside of what you talked about. I don't know how you would define that. The subpoena, the encumbrance are so awful in this thing for law enforcement, the hoops to jump through, that anybody thinking about a system like this would just say no. But all the people that have it, and that's why I say if you pull the bill back, then law enforcement doesn't have the audits. They don't have the logbooks. They don't have the hoops to jump through. They don't have any of this thing. So I'm giving credit to law enforcement for sticking in this game to the end, because without a bill, which there wouldn't be if we can't come to an agreement, they've got everything that they wanted, save the protection of the privacy if we put that on again. So I'm kind of at a loss of what to do, because if the amendment passes and comes to my committee, it's a non-starter out of there. So can I go through the points here that the bill now?
Certainly.
We do thank you for the move in the retention, but such a short retention period really limits the technical, the capabilities for law enforcement. And it was said that there is a state that went to a 7-day retention period recently, but I say to that, so what? I actually believe the retention periods are going to get longer, because the more this system is used and the more major cases it's solved and found out how valuable it is, I think the retention periods will get longer. The only reason I think it was such a short retention period is admittedly LPR data hasn't been out in the public eye a lot. When they found it, and then certain people say, and I'm not saying you folks, but Armageddon is going to happen and the sky is going to fall in, they look at shorter periods. Once they realize what the bill does and the capabilities we have of solving crime, I think that the actual retention periods will get longer. And to take one state and say they passed a 7-day retention period, that's the lowest in the nation. It's almost unheard of. I mean, Texas has the death penalty. Are we going to model our state after that? So to cherry pick one state out and hang your hat on the short retention period, we don't think is really fair. And we've talked to you folks about crimes reported a week or a month or a year after they occur. That's why we need the longer retention period. The warrant lines, we feel it's unreasonable to ask law enforcement and the courts to issue a warrant to view a license plate on a vehicle on a public street. The only difference there's some differences between this system, but an officer can enter literally hundreds of license plates into the MDT right now on a check on a given night. Now you're talking about basically the same system and having a warrant. The annual audits, we support annual audits. Our idea was once in every 3 years. We thought you folks might, come down to 2 years or 1 year, but I mean, 4 audits a year? It just seems totally unreasonable. It seems to me that some of the advocate groups sensed that we were coming close to a reconciliation on the time, and they got so worried about that, they decided to kill the bill by adding other things once the retention period was going to be better, because even if you gave us a 30-day retention period, all of these things makes the use of the technology so encumbersome. The disciplinary lines of 513 and 525, we support the law that took effect in August of 2014 that makes unauthorized access of a government database a criminal offense. We wonder why we didn't mirror that instead of jumping into disciplinary actions at a local level, why we didn't just take up something similar to that. The sharing of the ALPR data, the sharing among the police agencies is critical to solving crimes quickly, and we support safeguards, including a legit law enforcement purpose or reasonable suspicion. The administrative subpoena, I think with all that, is not necessary, and it's just one of those hoops, again, that I think that we have to jump through. The centralized ALPR database, In order for this to be effective, there's got to be a centralized database that stores license plate numbers of vehicles that have been reported stolen and wanted in connection with a crime such as Amber Alert. And the BCA currently provides such a database, and we support that in continuing. This was a Senate floor amendment last year and wasn't intended to be in the initial draft language. And then there's a section here about drones in your, I didn't even want to, go ahead. And-
Yes, Representative Cornish, that's on the first page, and that's just in the definition of surveillance technology. That's the only reference there.
And the whole drone thing, I didn't even plan on hearing anything about that in my committee. You're addressing that, and it kind of just gets in a little bit that other people are going to jump onto, that anybody that wants anything done with a drone, once we enter that into the language. So, Madam Chair, I don't know how we fix it, because it's put in a DE1 amendment. If there was in separate amendments, I appreciate the movement on the retention period, but it's everything else here takes away any attractiveness in the bill for me that had, even with the short retention period. So I don't know where to go from here, because if, like I say, if the amendment's defeated, then you're not going to be happy, and we're not going to come to a resolution, because we have to have this on the floor. And so I don't know how to address this. I'll leave it up to you folks how you want to play this out.
Representative Cornish, before we move to member questions, I'd like to hear from members of the public on the DE3. Quickly, if anyone would like to have any words about it. Go ahead and introduce yourself for the tape, please.
Madam Chair, for the record, my name is Rich Newmeister. One has to take a look at what is the basic issue here. You've got interest, privacy, liberty interest, new technology. Law enforcement wants to use this technology. Secondly, we also have to take a look at the history in Minnesota of how law enforcement has abused some of its authority that it's had just in the last decade. Whether it be MJNO, where millions of records were kept on many citizens in a private organization. Number two, GangNet, thousands and thousands of people were just put in a database, which is now closed. The whole issue of DVS. And there are other kinds of things happening locally, statewide, and nationally, where people are saying there needs to be accountability. This is what this bill, the DE3 amendment, does. And first of all, the Privacy Commission has been very strong to say, hey, what's out there in the community? What's out there? And so one of the things is the inventory. This is an attempt to get an idea of the kinds of technology that's out there. The DE3 amendment is a lot of the same language that's in the DE1, which is basically from the Senate. And there are some changes. The definition is truly the definition that should be used from all data collected from these devices, rather than a defined definition, what you have in the proposal. One of the other things that I think is important is that, Madam Chair, as Representative Johnson indicated, he saw on his ride-along on how people were putting things in their own little type of database, or he came to that point of view. So what 3.6 through 3.10 says, you're only going to use the database, the data file that's currently under law. People know what's being put in there, and there's an exception, except the locals can do their own if someone is being investigated. On lines 3.9 and 3.10, a central state repository. In Maryland, in California, in other places, they're doing centralized databases on innocent, non-hit scans. This is not the centralized about databases. This is on keeping millions of scans on innocent, law-abiding people of where their locations, and with those pictures, those kinds of pictures that have been part of the testimony. 7 days, it goes off, to where there's some movement. Secondly, some of the quarterly audits, I think, are important, or some type of audit. Quarterly is one of those things, and that can be used, for discussion. I have no problem with the subpoena. in the issue of where, on the First Amendment rights, we are already aware that LPRs are being placed at gun shows, protest rallies, churches, whatever it may be. It's very, very clear what First Amendment activities are. I think it's important, and that type of policy is very similar to St. Paul's surveillance policy that they adopted several years ago,
Madam
that
Chair.
there needs to be a sign-off.
Madam Chair.
And
Question for Mr. Neumeister on that point.
Representative Lesh.
Thank you. Before I ask a question of Mr. Neumeister, he was just speaking about the First Amendment activities, subdivision 10. Can you tell me, how did that language come into the DE3 amendment?
Representative Lesh, that was a concern of mine because I knew that, that this had been occurring, if not in Minnesota, other places where law enforcement was scanning the license plates at gun shows and those sorts of activities.
Okay. And thank you, Madam Chair. The question I was going to ask is, how we, how, how that works, because the First Amendment is a prohibition against prior restraints. And I don't know how we anticipatorily, maybe you can answer Mr. Neumeister, how would we anticipatorily determine that an assembly is protected by the First Amendment in light of the fact that the First Amendment is simply a prior restraints prohibition? And if you just want to bypass and say, wait for the lawyer, that's fine too.
I'll wait for a lawyer, but I'm trying to
Okay.
do some common sense.
Or Mr. Neumeister.
Madam Chair, Representative Lesh, for me, I just look at it from a common sense perspective. LPRs have been used at demonstrations, at churches, whatever, across the country. And possibly here, I don't know. And so it's just like when law enforcement observes or they infiltrate public meetings or things like that, which is recently with the Bloomington MOA. Generally, some departments, what they have a policy. It says if law enforcement has to do something with a First Amendment activity, generally, there has to be some accountability to that. And all I'm saying is that I've seen when law enforcement has been observing political rallies with the RNC here in Minnesota, in St. Paul, there's a lot of policies. They were even sued over that recently. And they've come to some policies, at least in St. Paul that I've seen, where there needs to be some authorization before there's monitoring of First Amendment activities.
Well, and
Madam
Madam Chair, the reason I'm asking is I think this language is potentially workable. I hear Representative Cornish's statement that he has concerns about it, and I think I see why based on my question. But there's probably a way to work through that, because I have some of the same concerns. I wonder where you can park a reader to get a whole pool of individuals that you think are doing something wrong when you don't have individualized suspicion. And I wonder if the DE1 amendment has taken care of that, to the extent that if law enforcement is surveilling a pool and they happen upon something that they weren't looking for, based on that articulable suspicion contained in the document they just said they're going to submit, then any evidence collected based upon that surveillance is gone. It's out, because it's fruit of the poisonous tree. So I wonder if that isn't enough of a safeguard against it being used in the method that you stated. Do you think it's not?
Mr. Neumeister.
Madam Chair, Representative Lesh, I'm not going to answer. I got to think a little bit more on that. Madam Chair, if I may just finish on just a
Sure.
couple more points. One is, there was discussion. When you set one of these cameras, which is rising with technology with facial recognition features and other kinds of things, in front of a house for a specific person or a location, there is a privacy interest. And that's where some discussion, states, whether it's statutorily or by case law, are starting to say privacy interests are expanding. And so I think there should be a warrant in a particular place if you're going to use this kind of technology, particularly as it advances. One of the other things, again, little differences in this amendment, when you're talking about audits, then the DE1, it doesn't say audit how the data is used. It's basically, is it classified or some other thing? One of the important things is when you do audits, you want to take a look how the data is used. And so that's another little word that's placed on this section. So, Madam Chair, for Representative Cornish, he's very much entitled to his opinion. And I've known Representative Cornish for decades. And him and I go back and forth. I help him on some things. He, on another point, believes on some things. He helps, we exchange views. But he knows that this is a big issue. And I think I hope, is open to some of these kinds of things rather than just dismiss the whole bill or the whole attempt to try and, for some accountability, transparency, as these two strong interests are butting up against each other. So, Madam Chair, members of the committee, I encourage you to continue on to adopt this amendment and continue on with the discussion.
Thank you, Mr. Newmeister. Anyone else in the public wishing to testify? Mr. Gimberling. Go ahead and state your name for the record, please.
You bet. Madam Chair, Don Gemmerling from Minnesota Coalition on Government Information. If I remember correctly, the inventory of surveillance technology, which is in Section 1 of the DE3, was in the original bill, if I remember. And at the time, I think we said that this is a good thing. As we go into the advanced era of surveillance technology, part of what I've come to believe is you can kind of limit the abuses with greater transparency, okay? Are there going to be abuses? Well, history tells us, yes, there are going to be abuses. But to the greatest extent that the public knows how law enforcement is using technology, the better off we're going to be, and the better off you're going to be able to make decisions, okay? So having an inventory, for example, is a good example of that. I'm not going to go into a lot of technical stuff in the bill. Frankly, even though we've supported zero retention from day one, we know, number one, that's not practical, and number two, it's not going to sell. So is 7 days a reasonable compromise? It's a compromise, let's put it that way. And I wish Representative Leschko, he's right there. The First Amendment thing in subdivision 10, that kind of language appears in other states' laws limiting the collection of that kind of information. Now, frankly, off the top of my head, I can't give you one of those states, but I know in the 40-plus years I've been doing this, I've seen that kind of language, and it's usually in some kind of law limiting the government's collection of information about First Amendment activities. There is the possibility, given Representative Lesch's concerns, that it could be fixed a little bit to make it clear that what you're trying to prohibit is the use of technology that's trying to surveil the exercise of rights under the First Amendment, okay? And that exercise includes the right of free speech, the right of assembly, the right to petition the government, and the right to exercise religion, okay? Without governmental interference and hopefully without governmental surveillance. So, we're going to support any kind of compromise that's reasonable, but of course we're all going to disagree about what is reasonable. And I think this is another attempt to come to a compromise. And we appreciate your efforts.
Thank you.
If you have any questions, I'd be happy to answer.
Okay. Doesn't look like anyone has any questions. Anyone else, member of the public, wishing to testify? Go ahead and state your name for the record, please.
Madam Chair, members of the committee, Jim Franklin, Executive Director for the Minnesota Sheriff's Association. Specifically with the DE3 amendment, we do not support it. There are a number of problems. I would just point out a few things that I think are problematic in the language and how we implement it. If you go to line 1.8, if you talk about personal characteristics, as an investigative officer and detective, I would use Google and I would search from my computer a person's name to try to determine information that may or may not be relative to my investigation. Under this bill, in terms of inventory, my computer potentially at my office becomes something that we would use in tracking purposes. It also talks about Facebook and activities of an individual. I mean, if I go on Facebook and all of the other kinds of things in my investigative duties, would that then comply? I talk about property of an individual. If you have real estate transactions or other kinds of things that you can track electronically, all of these kinds of things, is that technology covered under this inventory that we as governmental agencies or entities would have to report? I would also draw your attention to surveillance technology on line 115. The way I read this, as you know, we use surveillance technologies in jails all the time. Building, public works buildings, the Capitol. The way I read this, we will all have to file annual reports on all of the cameras, all of the technologies that we use in all of our governmental entities, jails and everything, every year for every change that we come in with. There's a number of other things in here. 7 days is a movement. Obviously, we want more time. We have a double-edged sword in law enforcement. We need to prove somebody did the crime. We need to exonerate people that they are not involved. And so as we go through and look at this bill, there's issues, and some of these have already been highlighted, and I won't take up any more time. I just want to alert you to the fact that we have concerns about this bill. Be happy to go into much more detail, but I think in the interest of time, I'll just conclude with we're not in favor of the DE3 amendment.
Thank you. Anyone else wishing to testify? Okay, first of all, I think Representative Schoen, you were first on my list.
Thank you, Madam Chair. So how much do these quarterly audits cost?
Representative Schoen, I don't know.
Madam Chair, who's gonna do them?
That's up to law enforcement to find someone to do them.
So, Madam Chair, our local governments are gonna be forced to pick up the bill for quarterly audits, and they're gonna have to hire somebody, some random private entity to come and do quarterly audits on private data?
Representative Schoen, the amendment that Representative Cornish had an audit every 3 years, do you think that that's adequate?
Madam Chair, I do. I support Representative Cornish's bill, and 3 years seems adequate.
And
And that's
so
the
Representative
compromise,
Schoen-
but quarterly is burdensome. I mean, that is unheard of.
Representative Schoen, you are aware that in the past, law enforcement has abused the law by looking at innocent people's data, mine included in that. You're aware of that. And had the audits been done more frequently on that, maybe it wouldn't have gone on for so long. So, quarterly may be tough, and maybe we'll land somewhere in between. But once every 3 years is not adequate. It's a non-starter.
Well, Madam Chair, when you say that maybe audits would have done it well, quite frankly, when you're talking about the driver and vehicle services website, you're talking about a different thing. I understand where you're coming from, but, we've taken steps to make sure that the access to that data after the fact is protected more than it was when it was first brought out. And so the steps in DVS have taken the right direction that they've needed to. And we're trying to do that here about saying, here's how you can access it. That's the important part. Quarterly is just, if you're gonna do something like this, then there has to be remuneration from the state, because that's an unfunded mandate at that point. All I will say is, if you don't want license plate readers, then introduce the bill to ban license plate readers.
Madam Chair.
Representative Lesh.
Madam Chair and Representative Schoen, I think we need to remember where we came from here. Because the suggestion that, oh my gosh, our hands are being tied, why don't you ban license plate readers? If we were talking about hit data, that would be one thing, okay? The express statement is we want license plate readers to take care of all the work cops had to do in tracking hit data that they used to have to do. But this entire conversation for 3 years now has been about the non-hit data, which was not available unless cops were taking those little Post-it notes in their squads, handing them off to the secretary down at the office, and they were hand entering them into a database, which was not happening. So the 99% of the stuff we're talking about is the non-hit data, and that is a significant new either tool or concern, depending on how you want to look at it. And I just think it's a lot more complicated than said, well, we want to ban license plate readers, because I know that for me, that's not true. The technology is out of the barn, it's going to be out there, but some of these safeguards, I think, should have a reasonable conversation, and I think what Representative Scott is offering as an amendment is legitimate. And you might be right. You know, quarterly, wow, administratively, it's going to be impossible. I could be persuaded on that, but I still think the conversation is important.
Well, Madam Chair, Representative Lesh, I mean, not that I always agree with Mr. Franklin, but I mean, that's a great point on all our cameras and everything else. Everything is under surveillance. I mean, it's not just license plate readers that may affect. That goes a whole different direction.
Representative
So
Jones.
I don't know what the answer is here. I mean, at this point, if you're a non-starter and he's a non-starter, then let's vote on this and kill it here then, and call it good, and just let it be what it is, what it was going to be without legislation.
Representative Johnson.
Madam Chair, I have a question for Mr. Franklin. Still happens to be here.
He is. He's coming forward.
Mr. Franklin, on lines, on the DE3 amendment, on lines, basically it's 4.26 and 4.27. I'm just wondering if you're aware of any legislation ever passed or even introduced in the past where a law enforcement agency, because of a small error in a inventory or audit, lost their ability to use a piece of equipment until the legislature authorized them by statute to be able to do it again.
Mr. Franklin.
Madam Chair, Representative Johnson, in my 40-plus years of doing this, no.
Representative Johnson.
Thank you.
Representative Hillstrom.
Thank you, Madam Chair. I'll ask for a roll call.
Thank you. A roll call has been requested. Any further questions from members? Members of the committee? Representative Hoppe.
Madam Chair, I was just going to ask for a point of clarification. Are we still on the DE3 amendment, or are we?
Yes, Representative
Okay, thank
Hoppe.
you.
We're still on the DE3. Members, the intent of my DE3 is to put some really tight guardrails on use of the information. And as Representative Lesh said, most of this is because information is being gathered on innocent people. The hit data is one thing. The non-hit data is a completely different matter. When we're collecting information and it's in the hands of in the hands of law enforcement on innocent people. And I'm certainly willing to work with Representative Cornish going forward, and I hope that maybe I should ask him to come to the table again and just get his word on record that if I withdraw the DE3, that we will move forward. We'll pass his bill as it is amended with his amendment, but that's not the final word on this subject.
Madam Chair, before you bring Representative Cornish to the table, Madam Chair, in the event that any of these provisions get amended into Representative Cornish's bill, I would assume that the bill would be coming back to this committee so that we could take a look at these data pieces. And Madam Chair, even if you withdraw this amendment, I think I probably will reoffer it because I think this committee should take a vote on these issues if we're going to see it again.
Madam Chair.
Representative Lesh.
I think it's important to proceed in good faith here on this and not just draw lines in the sand. That's how we got 3 years into this in the first place, Representative Hillstrom. So I understand your passion on your side of the issue. I equally have as much passion on my side, but I don't think lines in the sand are a good measure at this point. I like what Representative Cornish and law enforcement has brought forward today with the DE1. I think it's worth further discussion, but so are the provisions that are contained in your amendment. So I would ask Representative Hillstrom, please reconsider the roll call piece.
Representative Hopping.
Thank you, Madam Chair. And I would like to say, we passed your bill. I think you're making a wise decision to keep working on this issue. I mean, clearly, this is not a partisan issue. Clearly, this is a contentious issue. Lots of testimony in for and against, lots of questions for and against from the table. I think that the truth is we're going to come up with something that's going to be somewhere between the bill before us and your amendment. So thank you, and thank you, Representative Cornish, Hillstrom, Lesh, everybody. Thank you all. Thanks. Appreciate it, Madam Chair.
Representative Cornish.
Madam Chair, if you withdraw the amendment and pass the bill out in the present form, I guarantee you that I have no intention of putting a bill out of my committee that you definitely disagree with, because I think that it'll never come up on the floor if that's the case. So I would be very interested in working with you in law enforcement and get everybody together, and especially, if we got time for like 3 minutes to run over the changes that have taken place, or do you rather?
We're done at 10, and I know Representative Applebaum has a question, so.
Just a couple of bullet points here. I just
Okay.
wanted to reemphasize the changes we made since we started out to now with the
Okay.
present bill. Go ahead.
Go ahead, Mr. Potts, introduce yourself.
Madam Chair, Jeff Potts, the Police Chief from Bloomington, and just to kind of highlight a couple of things. So we came into the session with plenty of things that were yet to be agreed upon, and just to kind of highlight, 222, the D1 amendment does do a few things that had not been done prior to the session. 90-day retention, that is in the bill. That's not something that would be in law prior to the session. Reasonable suspicion for access of the data is something that did not exist before, agreeing that, to try to calm the issue or calm the concern about the data existing and putting in place proper protections, identifying good protections, I think, is key to doing that versus just not holding the data. Our citizens really do expect us to be able to solve those cases, and those victims, as we're talked about, that data is helpful. So audits, the bill that is in front of you says 3-year triennial audits. I think in our group, we can agree that maybe there's some middle ground between that and quarterly. Quarterly is very tough, but we didn't have requirements for audits before. So requiring an audit, requiring the agency to articulate a reason for searching the data is a big step forward in that area of terms of trying to protect the data. Policies and procedures didn't exist before this session. So restrictions on access to the data didn't exist before this. I think we've come a long ways in terms of trying to come up with a compromise that really does protect the data, but also allows law enforcement to maintain the tool in solving these crimes. There are really good protections, and I think in the D1 that didn't exist before today,
Thank
before
you for
this
that.
session.
Thank you for that. Representative Applebaum, you have a question.
Thank you, Madam Chair. No, it's just more of a statement, really. This is the third informational hearing we've had on these issues, and I really think that we should address it here as, arbiters of the LPR program, and, the rest of the House looks to us for guidance on it. And, although I voted on zero retention before, I think, and while there's certainly some good ideas in your amendment, Madam Chair, structurally, I just don't think it's right, and I believe that it would indeed die, and in that case, passing no law in relation to this issue would be a travesty. So that's just my 2 cents. Thank you.
Thank you so much. Further discussion on this new plan. I will withdraw the DE3 in good faith with Representative Cornish, with the promise to work on some of these finer details of the bill. And with that, any further questions from members? Representative Hillstrom.
Thank you, Madam Chair. Madam Chair, I believe that this has some significant issues, and I believe that this is the proper place to deal with these issues. So, Madam Chair, I will offer the DE3 amendment, and I would ask for a roll call on it. Madam Chair, I think this has significant problems. I think this is the committee to address them in, and I think we should vote it down.
Representative Lesh.
To that point, I don't think that that is a good faith effort. When the chair has stated, Representative Hillstrom, that she's going to withdraw it, but in order to get a hash mark in your column, you want to jeopardize a negotiation process. So I would remind committee members that they are not required to take a vote on a roll call if they don't want to, and I won't be taking one.
Representative Hillstrom.
Thank you, Madam Chair. Representative Lesh, in our rules, it specifically says that when someone offers an amendment, that any member of the House can re-offer the amendment, even if the amendment is withdrawn. If Representative Scott wanted to, in good faith, proceed with negotiations, one of the things she could have done was offer these amendments to her own bill to keep it in place. She passed it on. Look, we have two bills on the same issue that are proceeding, and it's time that this committee take a stand on where we're going to end up. I think it's appropriate, and I think it's well within the rights of any member to offer any amendment. I think it's a bad amendment, and I don't think that the good faith negotiations have necessarily been going on, and therefore, I'm offering it, and I'm asking for a roll call. And if people don't want to vote on it, they can choose to take a pass.
With that, members, we are recessed.